Hello everyone, and welcome to Immigration Now. Today we're breaking down Bill C-12, a proposed Canadian law that could significantly change how the country handles immigration, border security, and enforcement. Whether you're applying for permanent residency, a study permit, or a work visa, understanding Bill C-12 is essential. Let's dive in. Bill C-12, officially titled the Strengthening Canada's Immigration System and Borders Act, was introduced in October 2025 during the 45th Parliament. To understand its purpose, we need to look at the bigger picture. Over the past decade, Canada has pursued ambitious immigration targets, welcoming record numbers of newcomers to fuel economic growth and address demographic shifts. This rapid expansion, however, has strained the system, leading to significant processing backlogs and raising concerns about program integrity. Bill C-12 is the government's response, aiming to modernize the framework to handle high volumes more effectively. It's crucial to understand that this is a bill, not yet a law. It must pass through several stages in the House of Commons and the Senate before receiving royal assent. This legislative journey can take many months, and the bill's text can be amended along the way based on committee review and debate. Once it becomes an act, the government will then develop specific regulations and operational instructions that guide immigration officers. These details will ultimately determine the bill's real-world impact on applicants. The proposed legislation is built on three core pillars. First, enhancing border security and enforcement. Second, strengthening immigration system integrity. And third, improving document verification and fraud prevention. In simple terms, the goal is to create a faster, more predictable system for genuine, compliant applicants by equipping officials with better tools to quickly identify and refuse incomplete or fraudulent files that currently clog the pipeline. The changes could affect almost every applicant type, from skilled workers and international students to family sponsorships. Let's dive into the core provisions of Bill C-12, starting with one of the most significant changes: expanded powers for early refusals. Under this bill, immigration officers gain more authority to refuse applications at the very first stage of review. If they spot incomplete documentation or believe an applicant might be ineligible, they can close the file immediately. This is a major shift. Previously, an officer might issue a request for a missing document. Now, even a minor omission could lead to a refusal, without any opportunity to correct the application. For example, imagine an international student who forgets to include their official letter of acceptance from a designated learning institution. Under the new framework, instead of getting a message asking for the letter, their entire application could be refused, forcing them to start over from scratch. Similarly, a skilled worker applying for a work permit might submit a job offer letter that's missing a specific detail required by the regulations, like a clear breakdown of duties. That single missing detail could be enough for an officer to issue a refusal on completeness grounds. The threshold for what constitutes a complete application is becoming much stricter. The government's stated goal for this change is to improve efficiency. By filtering out applications that don't meet the basic requirements from the get-go, the system is designed to speed up overall processing and reduce the immense workload on Immigration, Refugees, and Citizenship Canada, or IRCC. The logic is that by removing incomplete files from the queue early, officers can dedicate more time to assessing fully compliant applications. For applicants who submit a perfect file, this could mean a faster path to a decision. However, it places the entire burden of perfection squarely on the applicant's shoulders from the moment they click Submit. The bill also significantly expands the government's ability to scrutinize and verify your documents. This goes beyond just checking for authenticity. Officers could be empowered to request a wider range of additional proof to substantiate claims made in an application. This might include asking for detailed bank statements to trace the origin of funds, requesting previous tax filings to verify employment history, or even contacting educational institutions directly to confirm a degree. Furthermore, the definition of misrepresentation is broadened. It could cover not just outright fraud, but also accidental errors or omissions. If an applicant, or a representative acting on their behalf, provides information that is found to be misleading, even if unintentionally, it could trigger severe consequences. This is a critical point for anyone using an immigration consultant or lawyer, as you are ultimately responsible for every piece of information submitted in your name. And those consequences are getting tougher. The bill proposes stricter penalties, including longer bans on reapplying to Canada for any applicant found to have submitted fraudulent documents or misrepresented their situation. These bans could extend beyond the current 5-year standard. The net is also cast wider to capture those who assist in the process. This includes potential fines or other penalties for unlicensed ghost consultants, but also for recruiters or even employers who are complicit in providing misleading information to support an application. The message is clear: the entire immigration ecosystem is being held to a higher standard of accountability. Bill C-12 also strengthens the enforcement mandate of the Canada Border Services Agency, or CBSA. The legislation would grant CBSA officers more explicit authority to access private facilities, such as airports, marine ports, and rail yards, to carry out their duties. More critically, it aims to streamline the removal process for individuals deemed inadmissible to Canada. For certain cases, this could mean faster removals with fewer avenues for appeal or delay. While the government frames this as essential for maintaining national security and the integrity of the border, it's important to note that fundamental due process rights, like the right to counsel, are expected to be preserved. However, the timeline to exercise those rights could become much shorter. Another key provision involves enhanced information sharing. The bill would make it easier for an applicant's personal information to be shared between various Canadian government departments, such as IRCC, CBSA, and Employment and Social Development Canada. It also paves the way for increased cross-border cooperation with foreign authorities to verify information like travel history or past visa applications. On the technology front, the use of automated systems and artificial intelligence is set to increase. Digital records, biometrics, and other data points may be used to automatically flag potential risks in an application, which could route a file for more intensive review, or, conversely, fast-track it for approval. Finally, all of these changes are underpinned by a new flexibility for IRCC to reallocate its resources. The bill enables the department to shift personnel and funding away from processing certain application streams and toward key priorities like enforcement, integrity, and reducing backlogs in high-demand categories. In practice, this could create a two-tiered system. Applicants with straightforward low-risk profiles and perfectly compliant documentation may see their processing times speed up significantly. On the other hand, those with more complex cases or applications flagged as high risk could face even longer delays as their files are subjected to additional layers of scrutiny. So, what does this new landscape mean for you? In practical terms, these changes are expected to create a two-tiered experience. For those with well-prepared, transparent applications, the path to Canada could become smoother and faster. For others, new and significant hurdles may appear. Let's break down the potential impacts. First, the positive effects. Applications with complete, accurate documentation may move faster through the system. By weeding out incomplete files early, IRCC can redirect resources to processing compliant ones more efficiently. This means applicants using licensed and professional consultants who ensure every detail is correct from the start are far less likely to encounter delays. For example, a skilled worker in the express entry pool with a perfectly documented profile could see their processing timeline become much more predictable as their compliant application gets prioritized. Now, for the areas to watch carefully. DIY applications with even minor inconsistencies or missing documents may face swift, early refusal without a chance to correct them. Imagine a student forgetting to include a translated diploma. That could now be grounds for immediate rejection. The definition of misrepresentation is also broadening. Any past error on a previous application, even if unintentional, could affect your future eligibility and be flagged by new data sharing systems. Using unlicensed agents or recruiters who may not be aware of these strict new standards creates additional and serious risks for your file. The consequences are severe. Attempts to submit falsified documents, whether knowingly or not, could lead to bans of 5 years or more, jeopardizing your immigration future. In summary, Bill C-12 represents a shift towards a risk-screened system. Compliant, fully documented applications will benefit from faster processing. Those with errors, misrepresentation, or fraudulent assistance will likely face stricter scrutiny. Even though this bill has not passed yet, staying informed and proactive is the best way to avoid complications. Make sure your documents are complete, accurate, and properly verified. Using licensed consultants can help navigate the system safely. To build a C-12 safe profile, follow this simple checklist. That wraps up our overview of Bill C-12 and what it could mean for immigration to Canada. Stay informed, stay compliant, and you'll maximize your chances of a smooth process. Thanks for watching Immigration Now.